See more questions before we get started.
Oh, he just started the live.
Are you ready?
Hello, everybody online, and hello, everybody here in person. Good afternoon, and welcome to our final round of the 2023 intramural competition, not 1L. This is our upper class intramural competition, and I am so grateful for so many people. So I'm going to start with a couple of thank yous. First and foremost, I'm going to thank all of the students that participated. We're so grateful for you. I'm also going to thank our dean, Beto Juarez, who's going to speak in just a second, for his incredible support of our advocacy programs here at the law school. For those of you that don't know me, I am Professor Heather Baxter. I'm the Director of Legal Research and Writing, and I'm also the Faculty Advisor for the Moot Court and for NTA. And in my free time, sometimes I sleep. So I am so grateful that so many of you came out today on this beautiful Sunday. I know we'd probably rather be in here than outside in the rain today, but I am grateful for you all here. We're also grateful for Judge Bob Diaz, who facilitated our ability to be in this space today. It's so great to be back in person and to be in the courthouse today. So thank you so much, Judge Diaz. Thank you to Dean Juarez, and then also thank you to the incredible Moot Court Board. They have done so much work to put together this competition between writing the problem, Rachel Trottagot, thank you very much, to all of the support today, Jordyn Stein, where's Jordyn? Thank you, Jordyn Stein. And then, of course, the biggest part of planning this whole competition, Melissa DeSanti, thank you very much. And then we could not do it all without our Chief Justice, Kelly Mara. So thank you for everyone coming. I'm going to turn it over to Dean Juarez, who wants to say a couple of words.
Thank you so much. Good afternoon, everyone. I am thrilled to be able to be here and witness this final round of the competition. One of the things that this is one of the things that I get to do as dean is to observe the competitions that go on throughout the law school. And I can tell you, I sat in on a session yesterday morning and was so impressed once again with the high quality of the advocacy in these competitions. And the fact that we have these finalists, you know that we are in for a real treat. People keep telling me, oh, Dean, we're so glad that you're taking time on a Sunday. And my response is, I often have to do things on a Sunday that aren't fun. This is actually fun because it is going to be an opportunity to observe first-rate advocates. And I'm very much looking forward to that. I want to take a moment to recognize the critical role of the Moot Court Honor Society, and in particular its officers, but all of the student members of the Moot Court Honor Society. I'm hoping that sometime later this semester, there will be an important and exciting announcement about providing additional resources to our advocacy program, which is already an excellent program, but we want to take it to the next level above excellence. So I'm looking forward to being able to work on that in the coming weeks. And then finally, I just want to thank all of you for your participation and thank, most importantly, the judges who had taken time out of their busy schedule to participate in this final round. And I want to, in particular, note that we have alumni, we have judges who are faculty, we have judges who are students, but whether we're talking about Judge Bornstein, Judge Suppler, Judge Gann, Dean Cross, Judge Cross, or Judge Mara, it really is a very special thing for us to be able to observe them as they ask a few simple questions of our advocates this afternoon. So with that, I am going to ask Chief Justice Mara to please take over from here.
Thank you, Dean Juarez. So good afternoon, everyone. It's an honor and a privilege to be in front of you all today. I'm very happy, first of all, with our finalists. I think we should give them a round of applause. Four preliminary rounds, quarterfinal rounds, a semifinal round, and now here at the final round today. So I think that's something worth noting. We thank all the judges my wonderful and with unconditional support, my e-board, and also our G-board, who has just pulled so much weight this weekend. So thank you guys so much. But I know that this is about you guys today. So thank you all for putting so much effort into this. It makes our job worth it, and makes us feel so great that you guys cared and put all this work over the last 2 months, I believe it's already been. So thank you. And then to all our spectators, thank you guys for being here and showing all of us support today at our final round. And of course, for the judges for taking time today. There is no moot court without you guys, so thank you so much, and go easy on them, okay? And then one last thing, Melissa, please. And I just want to say thank you to Melissa, who has put this together. I've only helped, right? She has done this all from her own doing. So thank you guys so much, Melissa.
Hello, everybody. Thank you for coming. Thank you for watching. Now we're coming to the time that everybody's been waiting for. So I just want to say thank you again to Dean Juarez, Professor Baxter, Judge Diaz for letting us use this space and being so gracious with it. All the spectators, and of course my wonderful board and my wonderful G board would not have been able to pull any of this off without any of you. So thank you so much. So without further ado, I'd like to first introduce the competitors today. We have for the petitioner, Lindsay Brandwein, and Jordyn McManus. And we have for the respondent, we have Alyssa Rispoli and Sully Zagerman. And now to introduce our esteemed panel of judges. Presiding today will be the Honorable Judge Gam. Judge Gam attended Florida State University and obtained her undergraduate degree there in 1998. She then returned home to South Florida. She then returned home to South Florida and enrolled at Nova Southeastern University's Shepherd Broad Law Center, where she graduated with her Juris Doctorate. In 2001, Judge Gam began her career as an assistant state attorney in Broward County, where she served as a trial attorney for 13 years, to include time spent in the sexual battery unit and the homicide unit. Her 16-year career as an attorney also included time spent managing her own criminal defense practice, as well as performing a judicial clerkship at the 3rd District Court of Appeals. Judge Gam has tried over 100 cases to verdict prior to becoming a judge. She took the bench in 2017, following her appointment to the Circuit Court by Governor Rick Scott. Give it up for Judge Gam. Mr. Harvey Sepler, we love having you every time. Mr. Sepler is an appellate attorney and former assistant public defender in the appellate division for the 11th Judicial Circuit. He's been practicing for over 30 years and has litigated over 1,400 criminal and civil appeals in front of the Supreme Court and the Florida Supreme Court with unanimous victories. He is also a fellow of the American Academy of Appellate Lawyers. Next, we have Dean Cross. Dean Cross is the Associate Dean for Diversity, Inclusion, and Public Impact here at NSU. She also serves as a professor of law and the director of the Caribbean Law programs here. She received her JD from the University of Michigan and practiced corporate and banking law in Chicago and New York City. Additionally, she was a founding member of the Human Rights Action Network. And we have our wonderful alumni judge, Jonathan Bornstein. Jonathan graduated from the Shepherd Broad College of Law in May 2022 and currently serves as a judicial law clerk for Judge Jordyn DeMorgan of the 4th District Court of Appeal. As an appellate law clerk, Jonathan analyzes appeals and extraordinary writs encompassing civil, criminal, constitutional, administrative, and procedural issues. As Moot Court's Executive Justice of Academics last year, Jonathan created competition problems, spearheaded the brief grading committee, managed competition scoring, and directed the Society's fellowship initiative with NSU's University School. Jonathan and his team competed in the 2022 American Bar Association's National Appellate Advocacy Competition, where they were crowned regional champions. The team was also awarded Best Respondent Brief in the nation and was coached by our own Professor Baxter. And next we have our Chief Justice, Ms. Calimera. Calimera is a 3L here at NSU. She also serves on the Board of Law Review, and she will be taking the bar this July. So wish her luck. She's wonderful.
Amen.
So without further ado, I'm going to turn it over to the Honorable Judge Gam.
Good morning to all of you, and congratulations for making it this far. Before we get into character, take a deep breath. I look forward to hearing what you present. All right. Good morning, ladies and gentlemen. We're on the record in the matter of U.S. versus Walker. Parties, please announce your appearances.
Lindsay, Brandwein, and Jordyn McManus on behalf of petitioner Mr. Walker.
Alyssa, Rispoli, and Sully, Zagerman on behalf of the United States government.
Thank you very much. Is the petitioner ready to proceed with argument?
Yes. Good afternoon, Chief Justice Gam, Your Honors, and may it please the court. My name is Lindsay Brandwein, and I, along with my co-counsel, Jordyn McManus, represent the petitioner, Mr. Walker, in this case. Chief Justice, may I reserve 1 minute for rebuttal, please? Thank you. There are 2 issues before the court today. I will be addressing the first issue regarding hearsay, while my co-counsel, Ms. McManus, will be addressing the second issue regarding the confrontation clause. On behalf of petitioner, Mr. Walker, we respectfully request that this court reverse the lower court's ruling and hold that the tape recorder that was entered into evidence is inadmissible for the following 2 reasons. First, under federal rule of evidence 803 subsection 3, the tape recorder is inadmissible. And second, a fact that is believed to be true is nowhere included in the exception to the rule against hearsay 803 subsection 3. As to my first point, hearsay is an out-of-court statement offered for the truth of the matter asserted. There are exceptions to the rule against hearsay, which include 803 subsection 3 as a then existing mental, emotional, or physical condition of the declarant. However, nowhere in the rule does this extend to that of a third party other than the declarant himself. The admissibility of a declaration of intent for a declarant to go through with their intention may be admissible. However, such admissibility does not extend to that of a third party's subsequent conduct. In United States versus Joe, a Court of Appeals case for the 10th Circuit, the court stated that the purpose of the federal rule of evidence 803.3 is not to protect the factual circumstances that gave rise to the issue. However, it is to protect the then existing mental and physical condition that the declarant was in.
But Counsel, just so I'm clear, if I say that I'm going to the store to meet my good friend Lindsay Brandwein, is that admissible? I'm saying it about my conduct, my intent, and all I'm saying is that's why I'm going there. Is that admissible against you if you are later charged with some offense?
No, Your Honor, that is what we are arguing here today. That would be admissible against you for the truth, as that is your intent to meet with me. However, that would not extend to the third party, in this case, Lindsay Brandwein.
Why?
Because no one is in a better position to know a then existing mental state of mind or future intent than a person themselves. And that was held in Mutual Life Insurance versus Hillman. This court reasoned that because no one is in a better position to know their own mental state of mind, that cannot extend to that as a third party. And similarly, in this case, the voice recording of Mr. Ricketts' own intent to meet with Mr. Walker in the night in question cannot then be proved that Mr. Walker was actually there. There's no way to place petitioner Mr. Walker at the scene, as Mr. Ricketts' intent does not extend.
But doesn't that go to the weight of the evidence and not necessarily the admissibility or the applicability of the exception?
Your Honor, that does not go to the weight, as once evidence is entered into evidence, then it can go to the weight. However, this voice recording should not have even been entered in order to hear the jury, as it is prejudicial. And because the jury heard that, it did prejudice Mr. Walker, and in turn, there was no justice in this case.
So is your argument that it's more prejudicial than probative, or that it's inadmissible as the exception does not apply to this statement?
Your Honor, we are arguing that it is inadmissible as it does not fall under the rule of 803 subsection 3. However, because it was admitted, it is unreliable testimony.
Supposing that the issue of the case, I go to the store with the intention to meet you. So my statement on the recording is, I'm going to go to the store. If Lindsay is there, I'm going to talk to her. That doesn't do anything about you. That just gives a reason why I, who was ultimately deceived, went to the store. So that places me there. It doesn't place you there. So your intent has nothing to do with it.
Yes, Your Honor, it does place you at the scene. However, Mr. Rick, in this case, the you would be equivalent to Mr. Ricketts, and we are not trying to place Mr. Ricketts at the scene. We are trying to place Mr. Walker at the scene, and we hold that,
And the
as you
argument,
stated.
your response is that it's not relevant
Yes,
to you.
Your
That's
Honor.
the response. So
Yes.
it's really, all this 803 stuff is really not really, that's not right. Your argument is that it's not relevant as to you.
Your Honor, we are arguing that it does not fall under the exception to 803 subsection 3, which is at issue here. As stated, it is not fully relevant, nor does it go to the trustworthiness of the evidence that I actually did go to the store to meet you there. While that was your intention to meet me at the store, there's no way to further extend that rule to me and my intention to meet you at the store and talk to you if you were to be there.
Counsel, I'd like to expand a little bit upon that further question. So is it your argument that statements bearing on the intent of someone other than the declarant are never admissible? Or would you concede, for instance, in the Second Circuit, in the case of Best, there's corroborating evidence? How does that square with your position?
Your Honor, while Best does square with our position, I'm not so familiar with that case. However, in the case of People versus Alcald, it is California Supreme Court case. There was concrete evidence to place a defendant at the scene, as there was DNA in the form of hair that was able to further prove. In this case, there is no further evidence that actually places petitioner Mr. Walker at the scene, and therefore because the voice recording is inadmissible, as it cannot place Mr. Walker at the scene, there is no further evidence that can place him there.
But Counsel, I think that brings us back to the point that Judge Gann was making earlier. From my understanding of the record, I think there was eyewitness testimony that described someone fitting the description in this particular instance. So does that really go to weight, or is that more to admissibility in the sense of the corroborating evidence here?
Your Honor, while there was an eyewitness, that eyewitness is unreliable, and further, while the unreliability would go to weight, the eyewitness would go to corroborating evidence, which would make evidence more concrete. However, in this case, we're requesting that the evidence that it would make more concrete is the voice recorder, and we are requesting that this court reverse the lower decision and hold that voice recorder is not admissible in court.
Was the issue of an unreliable eyewitness